So we have some more news in the challenge against the ATF's pistol brace rule. The Trump DOJ recently agreed to drop their Fifth Circuit appeal in the mock lawsuit dealing with pistol braces, but the Trump DOJ and the Trump ATF may still be trying to enforce their interpretation that all brace pistols are SBRs. Let's break down what is happening in this critical case and what happens now going forward. We have some important news in the battle against the ATF and their current restrictions on all brace pistols and trying to treat them as SBRs. The Trump DOJ recently stipulated to the Fifth Circuit that they have agreed with the plaintiffs in the case to drop that appeal and essentially drop the challenge against the pistol brace rule. The prior nationwide vacatur of the pistol brace rule was appealed to the Fifth Circuit by the Biden administration, and that administration sought the reversal of the nationwide block that was put in place against that rule. However, once the Trump administration got control of this case, as the administration turned over, the Trump DOJ decided to settle and dissolve that appeal in the Fifth Circuit. Now that decision by the Trump DOJ to drop the mock lawsuit is impacting other pistol brace cases. Recently, there were multiple pistol brace lawsuits that have been dropped as moot, but now there is a third case and a very important challenge which was filed by GOA in the state of Texas and Ken Paxton. They're asking the court there to not moot their challenge, to not dismiss the case. But instead they point out that the ATF's continued enforcement of the brace restrictions is a major concern, and that's why this case should move forward. At the very least, instead of dismissing the case, they should get a permanent injunction which would block the ATF's current interpretation of the NFA and essentially also block their interpretation that the statute still allows them to restrict braced pistols as SBRs. This is important because if granted, it would prevent any future administration or even the current ATF from going after braced pistols as SBRs. You may recall that the pistol brace rule was put in place by the Biden ATF. Originally, it started because the Biden ATF wanted to interpret the statutory text in a way that they could include brace pistols as SBRs. Multiple lawsuits were filed against that rule, and eventually a lower court judge, Judge Rita O'Connor, issued a final merits ruling in the mock lawsuit and struck down the rule completely nationwide. In response to that ruling, the ATF decided to appeal to the Fifth Circuit, but then the Trump administration, of course, got in control. Trump won the presidency, the administration switched over, and in response, the Trump DOJ decided to pull the appeal and concede the ATF mock case. That was the first domino that kind of fell in a lot of these pistol brace cases. There were other lawsuits that are currently, some are active, some have now been resolved. You had some other cases in the Fifth Circuit in that jurisdiction like the GOA case, the SAF case, the Brito case, some other ones as well. Then you also had some other circuit court cases like the FRAC lawsuit. One thing that I do want to mention that I've been bringing out and pointing out for a long time is that there are some long game implications to these decisions to agree to drop these cases. By agreeing with the Trump DOJ to drop these cases, you get this kind of immediate win and you end the enforcement of the brace rule right here and now. But you also lose the opportunity to get a larger and more impactful final merits ruling out of a court of appeals. Remember that the mock case was only ruled on by the district court. If another anti-gun administration comes into office and they decide to take another crack at a pistol brace rule, the only precedent that you really have is out of a district court by Judge O'Connor in that mock lawsuit. That ruling is not necessarily binding on other jurisdictions, and it's only persuasive at best. Also keep in mind that that ruling was only based on the Administrative Procedures Act, also known as the APA, and it was based on some APA procedural issues which could be remedied by a future anti-gun administration. It also does not prevent the current or future ATF from saying that they can regulate brace pistols as SBRs purely based on the statutory language. That is currently where we have a big issue. There have been situations where the ATF, even after the brace rule had been conceded and struck down, and even after the Trump DOJ got control of the case, there were still situations where they said that they could no longer enforce its interpretation based purely on the rule, but they said that they could still do this based on their interpretation of the statutory language. They essentially said we don't need the rule. We can do this purely based on the statute. That is now being brought up by GOA and the state of Texas and Ken Paxton in their challenge against the ATF in their challenge against the pistol brace rule. Recently, GOA and the state of Texas and Ken Paxton filed a status report to the court there in their pistol brace challenge, and they argued that their case is not moot and it should be allowed to move forward at the lower court level because there is still a significant issue with the enforcement of this type of interpretation. They argue that instead of mooting the case and dismissing the case, they should get a permanent injunction against the ATF in their current and future enforcement of any pistol brace restrictions. In that report that was submitted to the court, it states that this court ordered a status report by October 24, 2025, if any party believes this case should not be dismissed because defendants appear to believe that they are free to continue to enforce the statutory interpretation underlying the final rule, even though the rule has been vacated. Plaintiffs' claims are not moot, and this case should not be dismissed. Rather, the court should enter an injunction permanently preventing defendants from ever enforcing their flawed legal theories against plaintiffs. They went on to state that the subsequent activities by defendants raise serious doubts about their willingness to comply with this or any other court's ruling. For starters, the rule was vacated on procedural grounds, failure to constitute a logical outgrowth of a proposed rule, not a rejection of defendants' underlying statutory interpretation. Without injunctive relief, defendants are in a position to simulate enforcement of the rule merely by referencing to the underlying statutory scheme defining NFA-registered firearms. They point out that, as defendants argued, neither the Brito Court nor any other court has held the rule is an incorrect interpretation of the statute. All the court's holdings turn on purported defects with the rulemaking translation. They state defendants believe they may continue to enforce the substance of the rule by simply referring to the statute instead of the rule. So even though the rule was vacated, plaintiffs have not received all the relief they sought, and certainly not all of the relief they need to be protected against defendants' flawed reading of the statute. Rather, defendants seem intent on continuing to interpret the underlying statutes in parallel with the now vacated rule. What GOA and the state of Texas are pointing out in this pistol brace case is that the ATF may be trying to do something kind of sneaky right now when it comes to pistol braces. They agreed to drop all these lawsuits. They agree that the pistol brace rule cannot be enforced, and they're going to allow that nationwide vacator to go in place on the rule itself, but they may still intend to enforce restrictions on brace pistols. They're leaving that door open purely based on their subjective interpretation of the NFA statutory language. Currently, nothing stops the Trump administration or future administrations from doing that thing if an injunction is not put in place on that interpretation. It's good news that the GOA and Texas are trying to get this further relief in the case. They're not just willing to dismiss the case. It will now be interesting to see how does the administration respond to this. It's going to be telling and ultimately will reveal what does the current administration believe about pistol braces and if they can still regulate them purely based on the statutory language. That's something that we're going to have to watch closely going forward to see how the Trump administration responds to this. When it comes to the NFA, the Trump administration definitely has been all over the place. I would not necessarily be surprised if we see some language where they say yes, we can still restrict brace pistols as SBRs under the NFA, and maybe they want to leave that door open purely based on the statutory language. Again, that's something we're going to be watching closely as we get more information. As this unravels more, I will let you guys know.